All right, good afternoon. Today we're going to be talking about Rule 50, judgment as a matter of law. Now let's start off by looking at our handout on the different types of dispositive motions. Let's remind ourselves of how these motions work, and specifically the gatekeeping rule done by Rule 12e6, Rule 56, and Rule 50. In a sense, they all do the same thing, and that all are geared towards determining whether or not the case should continue. And particularly in the cases of Rules 56 and 50, the question is, must a reasonable fact finder find in favor of the moving party? If a reasonable fact finder must find for the moving party, then judgment as a matter of law is appropriate. Now, that can mean, in the case of Rule 56, that there's not going to be a trial at all, right? Summary judgment could be on just an issue, or a defense, or a claim, or the entire case. Ultimately, the question in Rule 56 is, if a reasonable fact finder must find for the moving party, then we don't need to have a jury decide that issue, right? And that may mean no trial at all. In that sense, Rule 56 is different from Rule 50A and 50B. Because a grant of summary judgment under 56 may mean that there's no trial at all, right? Because we don't need a trial. A trial is to find the facts, and if the material facts are not in dispute, don't need a trial, we go straight to judgment as a matter of law. In Rule 50, there's a trial, right? Now, in Rule 50A and Rule 50B, it's again the same question. Must a reasonable fact finder find in favor of the moving party, right? If so, then judgment as a matter of law may be appropriate. However, unlike 56, we are now in trial, and that's where 50A and 50B become relevant. In 50A, the trial is ongoing, right? Witnesses have testified, documents and other types of evidence have been introduced. And here the question is not whether or not we need a trial. We're having a trial. The question is should the trial continue on the issue, claim, defense, or entire case, right? So in other words, if a motion is granted under 50A, that may mean that there's no fact-finding by a jury on that particular issue. Or it may even be of such a magnitude that the trial is over, right? In that sense, it doesn't prevent a trial, but rather prevents the trial from then going to the state where the jury gets to decide that issue. A 50A is during the trial. A 50B is after the trial. The jury has spoken. The jury's found for whoever, say plaintiff, right? And now the plaintiff has won, got the jury verdict, and now the opposing party, the defendant, may move for renewed judgment as a matter of law. Pay close attention to that word, renewed, because that suggests that you're just redoing what you've asked for in the 50A. All right? The difference between a 50A and a 50B is 50A is during the trial. The jury has not yet had an opportunity to deliberate. In 50B, the jury has deliberated, the jury has spoken, the jury has announced its verdict. And now, the renewed motion for judgment of the matter of the law seeks to undo that jury verdict. Now think about that for a second. And now, I want you to think about terminology. 50A is also known as what? Directed verdict. And 50B is a motion JNOV. Judgment notwithstanding the verdict, right? Judgment non obstante veredicto, something like that in Latin. Right? The term directed verdict is a misnomer. When a court directs a verdict, it's not actually saying, hey, jurors, listen, I know we asked you all to come here to decide the facts, but I'm telling you how you have to decide the facts, and you better do what I said. It's not like that at all. When a court directs a verdict, it's not telling the jury to do anything. What the court's doing is entering the verdict itself on that issue, or claim, or defense, or the entire bottom line of the case, right? The court enters the verdict. Thus, the federal system has moved away from the older terminology because the terms judgment as a matter of law, and renewed JAMOL are more descriptive of what's going on. Having said that, judges and lawyers in the federal system, as well as the state system, will oftentimes still use the old terminology. The cases will use the old terminology, and we also will oftentimes use the old terminology. As a lawyer, I would expect you to be familiar with the old terminology as it's still in common use. Okay. The next thing I want us to think about is the differences between the burdens of persuasion and production. Let me pull up a graphic for you to use as part of this. Here we go. All right, this is from your case book. Granted, the order of trial. All right, P sues D for negligence. Who has the burden of persuasion to prove whether the defendant was or was not negligent? Plaintiff, right? Suppose the defendant uses the affirmative defense of contributory negligence, right? So the defendant wants to argue before the jury that the plaintiff himself was negligent, the plaintiff's own negligence contributed towards the plaintiff's injury, and therefore the plaintiff should get nothing. Who has the burden of persuasion on the defendant's affirmative defense? The defendant. Okay, so generally speaking, a party will have the burden of persuasion on their own claim, whether it's a claim or a counterclaim, right? And on their own defenses, whether that defense is asserted by a defendant against the plaintiff's claim, or by, say, like a plaintiff against the defendant's counterclaim. The burden of persuasion does not shift. Another way of putting the burden of persuasion is who bears the risk of not persuading the jury, okay? Who bears the risk? Now, in a civil trial for negligence, what is the burden of persuasion? Is it beyond a reasonable doubt, clear and convincing evidence, preponderance? What does preponderance mean?
More likely than not.
More likely than not. So if the scales of justice are here, or even better yet, this chart right here. All right, say over here is 0% evidence for the plaintiff, and on the other side is 100% evidence for the plaintiff. And right here is Z is 50-50, right? Suppose you're the jury, and you've heard the plaintiff, and you've heard the defendant, you're thinking, wow, did the plaintiff needed his burden, right? And you think, well, I'm 50-50. Jury decides we're 50-50. It's just as likely as not likely that the defendant was negligent. Who wins? The defendant. So who bears the risk of non-persuasion? The plaintiff. The party who has the burden of persuasion bears the risk of not persuading the fact finder, right? And to persuade the fact finder, the jury's got to be convinced that the plaintiff's version of the facts is more likely true than not, right? So if the jury is at equipoise, a term used in the Terry case, right? If the jury's at equipoise and thinks, well, no, I find both sides to be equally believable, then they would be instructed by the judge that the law they should use in deciding who to go with is, if you're in equipoise, is it equipoise or equipoise? It's poise. See, if you don't know how to say the words, it's like poison. Okay. Dad, you were. All right. Then you would have to find for the defendant, because the plaintiff can't win unless you're convinced the plaintiff's version of the facts are more likely true than not. Now, this line Z, is this a hard line or is this a very fuzzy line? Extremely fuzzy line. In fact, it doesn't really exist, right? Reasonable jurors can disagree where we are on this continuum. All right? So the reality is, as long as we fall between X and Y, jurors actually have a very broad range to determine who they find more, whose case they find to be stronger. That involves weighing conflicting evidence, right? That involves assessing the credibility of witnesses and all of that. Well, this is all about the burden of persuasion, right? you're the plaintiff on your claim, you have the burden to persuade the jury that the defendant was negligent, and that burden remains with you at all times. Summary judgment and Rule 50 are about the burden of production, right? It's about the burden of production. So in Rule 56, your burden as the moving party is to show a lack of dispute regarding material facts, right? And that you're entitled to judgment as a matter of law. You have a similar burden in Rule 50, right? To show that a reasonable jury must find in your favor, the moving party's favor. Okay? So, Rule 50 is not just about burden of persuasion, it's also about burden of production. Okay? And what I mean by not just about burden of persuasion, but also about burden of production, is these two interact, which we'll get to in a little bit. But let me illustrate this with a hypothetical. Go back to the order of trial, all right? Opening statements, right? Plaintiff's attorney gets up and she says, okay, this is what this case is about. I'm going to call these particular witnesses, and this is what I think these witnesses are going to show you. And please find for my client, blah, blah. And then the defendant gets up and says, you know, his variety of the stuff. And then the plaintiff presents her evidence, right? Her case in chief. So the plaintiff will call her witnesses. Those witnesses may be people that her client, maybe witnesses, maybe some employees from the opposing party. Think of, for example, the Lane case, right? In the Lane case, the plaintiff would have called Mr. Lane as a witness, and the plaintiff also called several of the managers from Hardy's restaurant as witnesses. They were plaintiff witnesses. Why are they plaintiff witnesses? Do you think Hardy's employees were there to help the plaintiff?
No.
No, but they were called by the plaintiff, right? So these witnesses had information regarding facts the plaintiff found useful to the case, all right? So the plaintiff determines the witnesses she wants to call and the evidence she wants to present. And as the plaintiff presents each witness, you know, she will engage in direct testimony of that witness. And then the opposing side can do, what's it called when the defendant now asks questions of the plaintiff's witnesses? Cross-examination, right? So say, you know, Lane's lawyer calls Lane and asks a bunch of questions of Lane and makes Lane look really good and aggrieved. Then the defendant asks some questions to make him look like a fool, right? Then the plaintiff gets an opportunity to engage in redirect. You know, to further clarify any of Mr. Lane's answers, to rehabilitate him if his credibility or his truth-telling had been attacked, all right? And this will go on and on. The plaintiff will call all of the witnesses, present all of the evidence, any documents, videotapes, whatever. And then the plaintiff will rest, right? And then the defendant gets to do the same thing. The defendant gets to put on its own case. Well, here's my hypothetical. It's the Lane case, and the lawyer for Lane, she puts on all of her evidence and does a really good job. And after she's done, she says, Your Honor, I rest my case. In fact, I don't think there's any need for this trial to continue. My evidence is so overwhelming that any reasonable juror, and you, ladies and gentlemen of the jury, look to be very reasonable people to me, I move for a directed verdict in my favor. Let's say the judge found Lane's case to be really strong. I know that's not what happened in the book, but it's a hypothetical, right? Say that the judge thinks that Lane's got a really strong case. Can the court grant a directed verdict to Lane?
No.
No. Why?
Because the judge is not there to judge the facts, and he's there to just verify that the facts only show that the moving party, the reasonable fact finder, will find for the moving party.
That's what I'm saying, though, Lily, right? That the judge thinks that based on the evidence put forth by the plaintiff, a reasonable fact finder must find in Lane's favor, right?
But he's the moving party. You have to wait until the other party presents.
Oh, why does the court have to wait until the other side presents their case, the non-moving party? Do you have any law to support that assertion?
The Rule 50A.
Oh, you want to cite the rules at me? Good. Yes, please. Point us towards the relevant part of Rule 50.
It says, if a party has been fully heard on an issue during a jury trial and the court finds that it's reasonably, jury would not have a legal sufficiency evidentiary basis to find for the party on that issue.
Now, okay, a party has to have been fully heard, right? Well, isn't that Lane's argument? I've been fully heard, and therefore I want judgment as a matter of law.
It's the non-moving party that has to be fully heard.
Well, why does it have to be the non-moving party that's fully heard? Use the text.
It says on A, resolve the issue against the party.
Well, yeah, fine, but doesn't Lane want to resolve the issue against the defendant?
Yes, but it's only presenting their evidence, so we don't have, or the judge or jury doesn't have.
You know that you're correct, by the way.
Yeah.
You know you're 100% correct, right?
Yes.
What I'm doing is pushing to really make clear who is the party. And it doesn't say non-moving party, does it? It says when a party has been fully heard. You can't have, maybe even an easier way of putting it is to put this before that. The court can resolve an issue against a party, right? According to Lane, what does Lane want? She wants, or Lane's lawyer, she wants the issue of liability to be resolved against whom?
Against Hardy.
Against Hardy's, right?
Right.
So the party in Rule 50A refers to the party who's going to have J-Mal entered against it. All right? So in other words, if you're moving for J-Mal, then the other side must have been fully heard on that issue. So going back to our order of trial, there we go. Our order of trial. There we go. My hypo was the plaintiff, Lane's lawyer, presented all her evidence, and then she, on behalf of Lane, moves for J-Mal. Why? Because the defendant hasn't yet presented its case in chief. So first it violates the rule, like Lily said. In fact, it would be probably a violation of due process under mostly any set of conceivable facts, right? That like, hey, we're going to resolve J-Mal against you, defendant, even though you haven't had a chance to put forth your own evidence. So if Lane's lawyer wants to go for J-Mal, then she's going to have to wait until after the defendant has presented its evidence. And at that point, either plaintiff or defendant can move for J-Mal, because both parties have been fully heard. Now, how about this one? Let's see. Actually, let's do it through this. Let's go to some of the problems in the problem set and use those. And the one we just did right now was number one, wasn't it? All right, so the answer here is no, Paul should not move for judgment as a matter of law because it's too early. Could Debbie move for judgment as a matter of law at this point? The answer is yes, right? Suppose the judge agrees with Debbie. So Debbie has moved for J-Mal after Paul's put on his case in chief. Debbie moves for judgment as a matter of law. Now let's assume that Debbie is arguing that Paul has failed to put forth any evidence of breach. All right? Suppose the court agrees with Debbie. Might the court deny the motion for J-Mal anyway? It might. So let's talk about the risks of a court granting judgment as a matter of law. Now think about the graphic we just looked at. All right, we're talking about J-Mal being done. Here we go. We're talking about J-Mal being done either here, right? Defendant moving for J-Mal, or maybe here, right? before the case is submitted to the jury, what happens if J-Mall is granted either here or here? Does the jury decide that issue? No. Say the court grants J-Mall here when Debbie's asking for J-Mall. And say the court now excuses the jury. The jury is dismissed. Jury is sent home. Jury, thank you very much, but I'm granting a directed verdict. The case is over. Thank you for your service. Go to see the clerk down there. You get your $12, $13 a day for your service. And the state thanks you very much for your time. It's actually a very important service that's being done, right? A case is over. Now, let's assume the directed verdict actually led to a complete victory for a defendant. The case is indeed over. There can be an appeal, right? Who's going to appeal? The plaintiff. The plaintiff. Who was the movement on J-Mall? The defendant. Who lost the case?
The plaintiff.
The plaintiff. Who's going to appeal?
The plaintiff.
The plaintiff. Let's say the Court of Appeal agrees. The plaintiff, like, Judge, you acted rashly. You used the wrong standard. The plaintiff did, in fact, have substantial evidence, and you should have allowed the case to go to a jury, right? You ended the trial, and you shouldn't have. Now it goes back down from the Court of Appeals to the district court. What's the district court going to do next? So the judge is going to get on the phone to each of the jurors, you know, and say, Brian, listen, Brian, how's it shaking? Listen, this is the judge. I need you to come back. The judge is going to do that. No. So we're going to have a whole new jury. So we have to have a new jury. So can we start the trial from here and move on?
No.
Where do we have to start?
From the beginning.
Beginning. So that's efficient. Not. Not efficient at all. So what a judge might do when presented with the 50A motion, the judge might deny it. I saw that in a GIF yesterday from the movie Gladiator, where the evil emperor goes like this, like, and his thumb goes up for just a second, and then it goes down, right? Even if a judge might want to grant J-Mall, a judge might deny it in the hopes that the jury will do the right thing. And if the jury does the right thing, then there's no need for RJMOL, right? At least by the defendant. And if the jury for some reason does the wrong thing, now the defendant has an opportunity to do renewed J-Mall, right, up to 28 days later. All right? And that way, say J-Mall is granted at this point after there's a verdict. All right? So the court grants RJMOL. The defendant wins. Who's unhappy? The plaintiff. In fact, the plaintiff's especially unhappy now, right? What did the plaintiff have? A dirty verdict. And it was snatched away from him, right? By the evil judge. Goes up on appeal. Let's say the Court of Appeals agrees with the plaintiff. District Court judge, we like you. We like playing golf with you. You're a very nice person, but your grant of RJMOL was inappropriate. The court reverses RJMOL. Do we have to have a new trial?
No.
Nope. The Court of Appeals can just reinstate the jury verdict. Much more efficient. So there's a reason why things are the way that they are, right? Okay. And there's further complications we'll talk about in the next class when we get to motions for new trials, right? When we get to RJMOL, a party can move for renewed judgment as a matter of law and include an alternative motion for a new trial. But we'll get to that in the next class. All right, let's look at a couple more of these hypotheticals. These are fun. All right. People today, we like calling on the peoples. Calling pretty much everyone in this class. Gabby.
Yes.
Gabby. Question number 2. Paul sues Debbie for negligence. After the jury comes back with a verdict for Paul, Debbie moves for J-Mall. May she?
I said no because in order for you to do, you, JMO? Unless the party previously made a rule on the 58 motion on the same issue.
You're close, but let's be clear about the question. What kind of motion is Debbie wanting to make? A JMOL or RJMOL?
JMO,
Okay, and when is she trying to make the motion?
after the jury comes back. with the
After the
verdict.
jury comes back. So that's 50A motion, right?
Mhm.
Can you assert a 50A motion after the jury verdict?
No, it has to be before.
It has to be before, right? Okay, why must a Rule 50A directed verdict motion, right, be sought during the trial before the case has gone to the jury? Why is that important? There's a good policy reason why. Yeah, kind of the why things are the way they are question.
Let's see. Okay, well, it says, one of the reasons or the functions of Rule 50A is that it notifies the non-moving party if they have some type of, like, to fix.
To fix
Why?
things, to cure.
Yeah, so it's
So
not
say
just an
you're Paul's lawyer, I'm Debbie's lawyer, and I move for JMOL after trial saying, Paul's lawyer didn't put forth any evidence of causation, but the jury's already spoken, right?
I never had like the choice to be able
Yeah,
to
is
fix
it,
that.
can you fix it now? Do we call the jury back to
No.
put some more evidence in the record? No,
It's too late.
right?
Yeah.
So if I'm going to move for JMOL, then I need to do it at a time to let you know what the holes are in
The
the
issue
case.
on why I would lose.
That's right.
Correct
Hey,
admission.
she's going to lose. Your Honor, she has to lose because she didn't put forth this stuff. I can't hide the ball.
That's
yeah.
what you have to specify in the judgment.
Very good, that's right. For judgment as a matter of law, has to specify the judgment sought and the laws and facts that entitle the moving to judgment. So, I can't say I make my motion during trial, 50A. Your Honor, I move for directed verdict during trial, at the proper time, after my opponent has been fully heard on the issue, yay me, because a reasonable juror just couldn't find her favor. And the judge says, granted,
No,
not appropriate, right?
no, because I don't know exactly why I need to fix and what the law is.
But I don't want to tell you, right, because I don't want you to fix the hole.
Yeah.
No, that's not how it works.
proper.
I would have to specify. Because the law, she sued my client for negligence. Negligence requires duty, breach, causation, and damages. My opponent, my learned opponent, hasn't put forth any evidence whatsoever showing that any alleged breach has caused her client any damages. And without any evidence of breach, she must lose as a matter of law. Now, I've
Now I
indicated
know
with the...
why, yeah.
That's right. And now you can say, Your Honor, sorry, I forgot. Here's my evidence of breach, and here's 3 witnesses that I'd like to call. Oops, sorry about that, right?
Yeah.
So you get the opportunity to cure your case. All right, now here's a counter hypothetical. Suppose does that fix things? Paul sues Debbie for negligence. After the jury comes back with a plaintiff's verdict, Debbie moves for RJMOL, right? A renewed motion for judgment as a matter of law. May she?
No, because you have to do a 50A motion before you can do a...
Can you hear the back?
No. You have,
These are all really good answers. They're like gold. The camera can hear you because it's right next to you, but the back of the room can't.
okay, in order for you to be able to do a motion, 50B, RJMO, you have to do a 50A motion on the same issue first.
That's right. And there's 2 reasons for it. And you've already given one, right? Is the opportunity to cure, for cure. All right? In fact, I'll give you 3 reasons. One is a policy reason. The plaintiff, or excuse me, the non-moving party ought to have an opportunity to fill any holes in their case, right? To cure any defect in their evidence. Reason number 2 is based on the text of Rule 50. So here's Rule 50, right? Now, first of all, the 50B motion is a renewed motion for judgment as a matter of law. Textually, the fact that the motion is being renewed strongly suggests that it's had to have been made earlier in order to be renewed, right? So the text. And the text further guides us. Note the language in 50B. When you make a 50A motion, all right, then the court, when there's a 50A motion and the court doesn't grant it, then the court is considered to have reserved that question for later determination after the jury verdict. Note the words, the legal questions raised by the motion. Gabby, what is the motion? When this sentence says the word the motion, what is the motion that 50B is talking about?
The 50A motion.
The 50...
Jamal.
The 50A Jamal motion, that's right. All right, so not just the title, but also the reference to 50A and the fact that the motion is referring to the 50A motion means that the 50B motion must have been made during the 50A. There must have been a 50A before you can have a 50B. So here's a question for the class. Suppose during trial, this is one of my hypos in the problem set. Question 3, Paul sues Debbie for negligence during the trial. Debbie moves for Jamal on the basis she owes no duty to Paul. The court denies the motion. It goes to a jury. The jury finds for Paul. After trial, Debbie does a renewed motion for judgment as a matter of law, and indeed she did do a Jamal during trial, right? And now the basis for the RJMOL is that there's no evidence. There's no reasonable juror could have found that Paul suffered any damages. Is this a proper 50B motion?
No.
And it's not, right? Because
Same definition.
it has to be the same issue that was raised in the 50A. And again, that's to avoid surprise to the non-moving party, right? So if you want to do a 50B, well, you have to have first have done a 50A, and second, have to have been on this for the same issue. That's right. Okay? Now remember how I said that there's 3 reasons why you can't have a 50B without a 50A? Right? One I said was policy, one I said was text. The third one is the 7th Amendment. Remember when we did the 7th Amendment last week and I said there were 2 clauses? There's the preservation clause and there's the re-examination clause. Re-examination clause says something like, no fact found by a jury shall be re-examined, by any court of the United States except in accordance with the common law. I hope I'm getting the exact language right. The basic idea is that courts shouldn't be re-finding facts found by a jury, right? Re-examining them. Well, think about RJMOL. What is the function of RJMOL? You can say it. Oh, did you, your voice? You lost your voice. You want to say something, but your voice is literally gone. Are you okay? Oh man, I don't do sign language. I wish I did. I will speak for you. Can you talk really quietly? Okay. Okay. Ignore this. What's the real function of RJMOL? To re-examine. Yeah. Let's be real about all of this. As a practical matter, what a Rule 50B motion does is undo a jury verdict, right? So I want you to go home and talk to somebody who's not a lawyer, say an old uncle or your grandma or your elderly next door neighbor, you know, just somebody who's not legally involved at all, and you try to convince them that a JNOV motion doesn't re-examine the jury verdict. Well, how's it work? Well, the jury verdict might have been for the plaintiff, and then what the court does is it throws away that verdict and finds for the opposing party. But that's not re-examination. It's not? No. Why? Because the Supreme Court told us so. So, the Supreme Court has created a legal fiction that The re-examination clause is not violated by a JNOV motion so long as there was a directed verdict motion prior to the case being submitted to the jury. That's why Rule 50B is phrased this way. It's a legal fiction. We're treating a 50B JNOV motion, an RJMOL motion, to use the different terminology. We're treating it not as if it's taking away the jury verdict. We're not treating it as it's re-examining the facts found by the jury, but rather we're just deciding later on a motion that had been made earlier during trial. Okay? So that's how the Supreme Court gets around any problems with the re-examination clause. And indeed, there were procedural mechanisms like this way back when. So the Supreme Court has upheld 50B so long as there's been a 50A on the appropriate issue at the appropriate time during trial. And that's how we get around any problems with the Seventh Amendment. Okay. Now what I'd like to do is move into the standard and the cases. So first, let's go back here. Go back to this. I want us to think for a moment about the Chamberlain case. I'm going to call somebody in a minute on Chamberlain. But right now, we're all familiar with the facts of Chamberlain, right? Let's assume who was the Enron guy? Bernie who? Madoff. Okay. Let's assume that we have 50 Abraham Lincolns having direct line of sight to what happened here, and we have one Bernie Madoff down here, okay? Can the court say, well, Abraham Lincoln, very, very good guy, best president we ever had, hold him in high regard, and he doesn't lie. And, in fact, let's make it even better. There's like another 50 George Washingtons along, with Abraham Lincoln. So we have, like best president ever, and another best president ever who didn't lie because of cherry trees and stuff. So they're all testifying they didn't see an accident, right? And then you have poor old Bernie Madoff down here, right, who got in all trouble for Enron. And, can the court say, I don't think this guy is believable, so I'm going to give credit to these guys? No? Would it matter if it was the other way around? Here's Bernie Madoff up here. There's one Bernie Madoff for the defense, and we have like 99 Abraham Lincolns and George Washingtons down here. I guess we lost one because I said 50 plus 50, and now it's 99. Tragic? Okay. Yeah, maybe the other one's like looking for a cherry tree. I don't know. All right. Put differently, can a court weigh the evidence?
No.
Whose evidence is more convincing or weighty? No. Can a court say who the court believes? Right? This is a more credible witness. This is a less credible witness. I believe this one, but not that one. Can courts do that? No. Then we have to start thinking about how do we explain the Chamberlain case, right? Kind of a neat case, kind of sad facts, and very worthy of discussion. So what I want us to get at with these two cases, Chamberlain and Lane, the main thing I want to get from these cases is, what is the standard you use in assessing a motion for JMOL, right? What evidence do you look at? Plaintiffs, defendants, or both? And how strong of a showing must the party make to either get JMOL or to avoid JMOL being entered against them, right? So that's going to require us to look at, among other things, this picture here, as well as this graphic from the Glannon casebook. The graphic that was Cipro Prof's use comes actually from another casebook, as Glannon gives credit. All right, so let's get somebody to start talking with us about Chamberlain. Jennifer, how about you? Okay. Sad facts, huh?
Yeah.
Okay.
So, the action was brought by respondent, who is Chamberlain, against the petitioner, which is the Pennsylvania Railroad Company, to recover for the death of a great man who alleged to have been caused by the railroad's negligence. So Chamberlain claimed in his complaint that the employees of the railroad negligently caused a multi-car collision, resulting in the deceased being thrown from the car.
And getting run over by a car, right?
Run over by another car, yeah.
So we got this guy, here's Bainbridge, all right? And imagine like Bainbridge is like way over here, and any accident, if it indeed happens, is like way over there, 900 feet away, right? What did Bainbridge testify to?
He testified for the respondent for Chamberlain,
Yeah, or for the plaintiff or the defendant?
for the plaintiff.
Very good, for the plaintiff. So what was his testimony? What did he have to say? Think about it for a second and put it in your own words.
He didn't say that he more inferred that accident happened there.
Yeah, what did he see and what didn't he see? I like your answer. He's inferring that there's an accident. The plaintiff is using Bainbridge as circumstantial evidence there was an accident, right? And specifically was an accident that was caused by the defendant, approximately causing the death of the decedent, okay? All right. So what did Mr. Bainbridge see?
He said that he saw the two string of cars, which one was piloted by the deceased, and then one was following the deceased train.
Good, so they're going this way, right? We've got
Yes.
3 strings of cars, right? 7, 2, and 9. All right? Which string of cars is the decedent on?
The second.
You know, the 2-car string,
Yes.
right? So he's a brakeman, right? So what was his job?
Third.
Yeah, but literally, like, what's this thing about a mound? Right? The tracks go up, and then there's a mound. And what happened after the mound? You see, we're going to be real particular on the facts here, and here's why. The question presented is whether or not the case should go to the jury, right? And ultimately, the district court, and finally the Supreme Court held the directed verdict was proper, and the case didn't have to go to the jury at all, right? Well, to determine whether or not we have enough facts to go to the jury, we'd have to think about what's the relevant substantive law, right? And what facts do we have? Are they substantial evidence that should go to a jury, right? So we need to get out the facts and then think about what the law is to determine whether or not we have enough to go to a jury, right? So that's why I'm asking about the facts. We're trying to figure out what is the plaintiff's case? What does Bainbridge have to say, and how does that help the plaintiff's case, right?
So I guess he controls how separate they are from each other, like the separate strings. So
Which one, Bainbridge or the decedent?
the decedent.
Okay, the decedent's a brakeman, right? Why do you need a brakeman on these strings of cars? Are these cars attached to a locomotive?
No.
No, it's just like 2 cars heading wherever, right?
So that they don't crash into one
They don't
another.
crash into one another. And what's this mound? What happens after the trains go over the mound?
It says here that they descend by gravity under the control of the hand brakes.
Yes. Think about it. Do you drive a car?
Yes.
I know we're in Florida, so we don't have a lot of hills. Have you ever driven over a hill? What happens when you go over a hill and you take your foot off the gas and the brakes?
You just slide down.
You slide down. What happens, have you ever driven up and down any mountains?
No.
Have you ever driven like in Pennsylvania or Virginia or anything like that?
I've been to like Tennessee
Okay, so what happens, you're at the top of the mountain and you're headed down the hill, and are you going to accelerate going down the hill?
No,
All right. What happens if you don't use the brake as you're going down the hill?
you don't stop.
You don't stop. In fact, do you keep going at the same speed?
No, you go faster.
You go faster. What law governs the fact that you go faster as you're going down? Is it Rule 50 or 59? It's gravity, right. So, one of the reasons for having a brakeman at the top of each line of trains is if the trains are getting too close to each other, or if they're going down a hill, use the handbrake to regulate the speed so they don't crash into one another. All right, so Bainbridge, did Bainbridge see any of these cars going past him?
Yes, I think.
He did. What did he observe regarding these two chains of cars? You know, in terms of their speed.
He said that there was, I guess, a loud crash.
No, well, that's not my question, right? I'm asking about the speed. What did he notice about the speed? Which was going faster?
The third.
And I,
So which one was going faster, this chain or this chain? The third string of cars is going faster. So here I am, okay, I'm Bainbridge, I'm here, and I see the cars going past me, okay, and I see the seat at the top of the middle chain. Look, hey, how you doing? And then I see another chain going past me immediately after that that's going faster, okay? Now what happens, you ever been tailgated? What's your fear about tailgating? Rear end collision, right? All right. Okay, so he sees this one, he sees this one's going faster. Does he continue looking at them?
No, he didn't pay any more attention.
He didn't pay any more, he's doing his stuff, right? Does he see a crash?
No.
Does he hear a crash?
Yes.
He hears a loud noise, right? Does he testify that that loud noise was these two chains crashing?
Yeah.
He testifies this? Okay.
So,
Could he testify it? Did he
no,
flat out?
he didn't see it happen, so.
Yeah, he may believe that's what happened, right? But he didn't see it happen, he heard a crash. What are possible causes of the loud noise that Bainbridge heard?
other, and cars.
List two. I can think of at least three. Give me two.
Besides a crash?
No, I mean just, give me at least two things that the loud noise might have been.
Something fell maybe from the train, or?
Okay, something fell from the train, metal hit metal. Okay, good. Give me another one.
Maybe the track, something went off the track.
Yeah, I don't know what the nature of the sound was. Could that noise have been these two chains hitting each other?
Yeah.
Could it have been these two chains hitting each other?
Yeah.
Could it have been other cars hitting each other elsewhere in the rail yard? Could have been some other cause that was just a loud crash. Yes, all those things are possible, right? All right. Which scenario has to occur in order for the defendant to be liable?
The third string of cars has to hit the.
This has to hit that, right? This has to hit that. And is it possible that this hit that? Sure. It's also possible that this hit that. If this hit that, then maybe the decedent was at fault, right? Right? I mean, I suppose the plaintiff could argue that this was going too slow and was the railroad's fault. They weren't making that argument, were they? Their theory seemed to be that this was going too fast and hit that, right? All right. So I think we've established that Bainbridge says he saw them pass, he saw this going faster than that, he saw the plaintiff on top of this car, he wasn't watching, he didn't see a crash, he heard a loud noise, which might have been these two crashing, and after the crash, he turns around and sees the decedent near the tracks, lying there dead. Okay? That's what he's got. Now, what does the defendant have?
The defendant has 3 employees who were riding in the 9-car string and testified that no such collision occurred.
So they're here, right?
Yeah, that there was no contact between the 9-car during
Very
the
good.
deceased.
Do they have any other witnesses?
No, I think they just have the 3 employees.
You sure? What about this? The line of sight witnesses, right? They have people with the direct view of what's going on. Now, there's one thing that Bainbridge testified that we haven't mentioned yet. Didn't Bainbridge say that he had saw these two sets of cars look like they were moving together? Right? Well, if they were moving together, does that suggest that they had hit each other? Could he testify as a fact witness regarding whether they were moving together? He saw it, right? Okay. What's the problem with that testimony?
That he just saw them, I guess, moving together, he didn't see the actual crash or the.
Well, true, but if he saw them moving together like they were in contact with each other, that would seem to be some additional evidence, right, that they had hit each other. There's a more fundamental problem with him testifying that he saw them moving together.
It contradicts the defendant's witness's testimony?
We're not quite at that point yet. Yeah.
He was almost a mile away, and the angle was too narrow for him to say that they were together, they were moving together, they were connected with each other, or they were
Okay.
not. He couldn't see that.
So how close was Bainbridge to the track? How far away was he from the track?
I think he was 30
Away
away
from
from the track. He was 30 feet in this position and 900 feet from.
It was like 50 feet away from the
Yeah,
track.
yeah, 50.
And between 800 and 900 feet away from the site of the accident. So the court says that's an angle of about 3 degrees. I'm not sure that the
3.3.
court's math is correct, okay? But the basic idea is right. All right, this would be like looking at your laptops from over here and saying that they're in contact with one another. They look like they're in contact with one another, but I have no way of knowing whether they are, right? Maybe this is probably 3 degrees, probably something like this. There's no way I can know. Optically, it looks like they're in contact, but I have no way of knowing whether they're in contact. Again, that would be an inference, right? Looks like they're in contact, but at that angle, you can't tell. Try it yourself. Those of you at the end of the row, get out of your seat, and take a look. Go like this. All right? Give it a try. You see what I mean?
No, you're.
You really can't tell. Alrighty. So this is good. So we have Bainbridge and we have all of the defense witnesses. The testimony from the defense witnesses, is that direct evidence or circumstantial evidence? It's direct. They're testifying to what they saw, what they know. Is Bainbridge's testimony solely direct? Is it solely circumstantial? Is it a mix? Yeah. He testifies, he has direct knowledge of seeing these go past him. He has direct knowledge of this going faster, right? He has direct knowledge that the decedent was on this car. He has direct knowledge and direct testimony that he heard a crash. But he lacks direct knowledge of whether this crashed into that, causing the decedent's death. He can't testify to that. So what the plaintiff is doing is wanting to give you what he has as circumstantial evidence of a crash that led to the death of the decedent. Okay? So now the court ultimately grants directed verdict, right? Here's my next question. And this is for the class. This is find the rule, please. Give me language in the opinion where the court explains how it's resolving a seeming conflict between what Bainbridge is saying and what the defense witnesses are saying. And my hint to you is it has to do with the role of direct evidence versus circumstantial evidence. Natasha's smiling.
Because I'm not sure if I got it or not.
You know what? Being wrong in this class is okay. Prepared students who have thoughtful comments that turn out to be wrong, that's just fodder, that's a learning moment. So what do you have, Natasha, page and paragraph?
I found on 1076,
Okay,
it's the 1, 2, 3, 4. It's where it says this is not the case in the middle of the bottom paragraph, not the last one. It's like, right? Yeah, all of that. Keep going, all of it, to the end of the paragraph. I'm not sure if that's correct.
that's close.
Okay.
Who says that? Is that the court saying that, or is that some other court?
It's the dissenting opinion.
From the decision below?
Right.
Okay, so that's a good, you're on the right track. Stephen?
Near the bottom of 1077.
Go ahead.
So in the last paragraph, a rebuttable inference of fact as set by the court in the Wabash Railroad case must necessarily yield to credible evidence of the actual occurrence.
Yes.
It is well settled that where plaintiff's case.
Yeah, and I saw, there's some other good quotes. I think this is the most helpful one, but there are other really, really good quotes. Nick, what were you pointing towards?
I was going to point to the bottom of 1076 into 1077. Then I realized that wasn't exactly what we were looking for. It basically just says what I was saying before, that there's no direct conflict.
No, actually, what you point towards is helpful. You mean this language, right? If there's a
yeah.
direct conflict of testimony, upon a matter of fact, it has to be left to the jury to determine, right?
Yeah.
And here, we don't have a direct conflict on whether the cars crashed, right? We have defense witnesses saying cars didn't crash. We have one plaintiff witness saying that he saw the cars headed, one was faster than the other, and he heard it crash. Exactly? All right, yeah. So, Lily, you had your hand up too?
Yeah, I was gonna go with both. I was gonna go a little bit beyond where Nick says and say, but here there really is no conflict in the testimony as to the facts, and then they talk about.
Yeah. Bainbridge didn't say there was such a collision, right? Okay, all three, very good. All right. So what the court here then seems to do is say that, you know, we're not weighing the evidence, we're not determining who's the truth teller or who's more credible in a sense. We're saying there's no conflict in the testimony. And in addition, we're not going to look at circumstantial evidence when there's direct testimony that's uncontradicted, that's directly on point. In fact, if you look in your case book, at the Reeves decision, which is noted briefly on page 1080, that gives a modern articulation of the substantial evidence standard. Look at all of the evidence in the record. Under the substantial evidence standard, a court will look at all evidence put into the record by both the moving party and the non-moving party. We draw the reasonable inferences in favor of the non-moving party, and we don't make credibility determinations. We don't weigh the evidence, because that's what a jury does. All right? Now look at the last sentence. The court should give credence to the evidence favoring the non-movement, as well as that evidence supporting the moving party that's uncontradicted and unimpeached, at least to the extent that evidence comes from disinterested witnesses. All right, now in this case, in Chamberlain, who is the moving party? The defendant or the plaintiff? The defendant, right? So we can look to the evidence supporting the defendant so long as it's uncontradicted and unimpeached. Now think about the evidence of the folks on the car, the folks with the unrestricted view of the alleged accident scene, who all testified they saw nothing, right? Uncontradicted, unimpeached. You might be a little troubled by the fact that that evidence came from who? Yeah, who are these witnesses? Railroad employees, right? Arguably interested. Here, however, the Supreme Court is pointing out to us that there was nothing raised regarding their credibility. They weren't impeached, their truth-telling capacity wasn't attacked. So here the court was comfortable with looking to the moving parties' uncontradicted testimony by witnesses with actual knowledge and direct testimony regarding the crucial matters at hand. Now look at page 10. (1077) and 1078. Now we know that in a J-Mal motion, the court is not supposed to weigh evidence. It's not supposed to determine credibility. But look at some of the things the court says on 1077 and 1078. At the top, there really is no conflict in the testimony, says the court. The defense witnesses, quote, flatly testified there was no crash. Perfectly clear. On the next page, the court says, Bainbridge's testimony on hearing the crash and the two strings were moving together is simply incredible. The court goes on to use this word, certainly. Do you think the court is gauging Bainbridge's credibility or not? Kind of is in some sense, right? It's not a well-written opinion, and here's what I mean by it. What the court ought to said is the language that Stephen pointed us towards a couple minutes ago, supplemented by what you guys were saying, okay? You were correct. As long as the court just said, hey, we have uncontradicted, unimpeached, direct testimony saying there was no crash, and all the plaintiff has is evidence that would cause at best an inference of a crash. And in directed verdict, we can ignore that evidence of the plaintiff and focus on the defendant/moving party's uncontradicted evidence, and therefore directed verdict is okay. The court should have said that and not gone any further. So if it had just limited to itself to what Nick and Stephen and Lily had to say, would have been a more palatable opinion. Instead, the court gets into a whole lot of discussion that kind of seems like it's just not believing Bainbridge very much. What kind of words does the court use when it's talking about Bainbridge? Grammatically speaking, what kind of words?
Suspicious.
J-Mel.
Yes, at the bottom of 1027 it says, not only Bainbridge's testimony considered as a whole suspicious, unsubstantial, and insufficient, but his statement that when he returned shortly after, that the crash of the string together is simply incredible.
Yeah, that phrase as a whole seems to be really just not believing Bainbridge. But let me clarify my question. My question is grammatically, what types of words are these? Really is no conflict. Petitioner flatly testified. It is perfectly clear. Simply incredible. Certainly. What kind of words? Adverbs. Those are adverbs. Remember how I say in class that adverbs are words used by people to pull a straight of BS over the truth. Your professor is usually very nice. What does that mean? That he's nice except when he's not? Right? But officer, I generally don't speed on Route 75, which of course means I don't speed except when I do, right? Adverbs are often used to vaguify things. Weasel words that allow something to both mean something and its opposite, all right? Your writing will be stronger if you avoid the use of adverbs. If you find the need to use an adverb in order to make your writing true, then you may need to revisit whether you have a very strong argument to start with. Try it. Next time you write something, you're done with legal writing, but next time you write something, try taking out the adverbs. Your writing will be a lot stronger as a result. In fact, the court here is using all these adverbs, says to my eyes, my BS detectors go off, right? You ever talk to somebody and say, well, certainly I'm correct? Well, if you're so certain you're correct, why don't you give me the reasons why you're correct, rather than just being conclusory, right? So, in my exam, try to avoid adverbs. Your writing will be stronger. You may realize by taking out your adverbs, you will come up with stronger arguments. When you realize you need to develop a point a little bit further before moving on to the next thing. All right, so we have Chamberlain, which held the direct verdict is appropriate. Looked at both sides' evidence. Now we're running short on time, so let me briefly summarize Lane. All right? Mr. Lane goes to Hardee's for breakfast. At some point, somewhere between, and you'll forgive me if I don't have the exact times off the top of my head, something like 10:15 till 10:40, 10:45, 10:26 to 10:45. Yeah, he goes to the men's room, right? He testifies there's water on the floor. He slips on the water, falls, hits himself, and ends up injured. And he sues Hardee's. And his theory of liability appears to rest upon the mopping, right? So the plaintiff, in the plaintiff's case, the plaintiff calls Mr. Lane, who testifies, as I've just said, and then calls a couple of managers for Hardee's, right? The plaintiff can do that. Plaintiff can call defendants or defendants' employees as witnesses during trial as part of plaintiff's case. So these managers testify that their policy is once breakfast is over, about 10:30, they mop up the bathroom, and they post a wet floor sign, a danger sign, a caution sign. All right. They don't testify what they did that day. They testify what the normal practice is. Okay? Now, for the plaintiff to win, the jury will have to believe that the water got there from whom? From Hardee's, right? From Hardee's. And that a warning sign wasn't put there, right? Because if a warning sign was there and he ignored it, that brings up defenses of probably not contributory evidence under the modern rule, but comparative negligence and maybe, I don't know, maybe assumption of risk. I don't know. You're the tort experts, not me, right? So for him to win, the jury's got to conclude that the water was from the Hardee's employees, but they forgot to put up the warning sign, okay? Is that possible? Might that have happened?
Yeah.
Okay. Is it also possible that there was a sign and the plaintiff ignored it or didn't see it? Yes. Is it also possible that there was no water there? Yes. Is it also possible that any water came from somebody else?
Yes.
You know, like suppose somebody went to the bathroom, made a mess on the floor, and left, and then 10 seconds later, Mr. Lane goes in and whoops, slips on the water, right? If the water had only been there for 10 seconds, can Hardee's be liable?
No.
Yeah, not if it's from a third party, right? It's got to be there long enough that Hardee's should have discovered it. 10 seconds isn't long enough. So, in this case, we have some direct evidence, right? We have the guy's testimony that he went to the bathroom at such and such a time. We have his testimony, direct testimony that there was water there, and that he fell and hurt himself. Can he testify that the water was placed there by Hardee's? No, he doesn't know that. Have we gotten testimony from Hardee's employees that the water that was there from them? No. Have we gotten testimony from Hardee's that they forgot to put up a sign that day? No. So for him to win, the jury's going to have to infer facts from the facts given through the testimony. Would you agree?
Yes.
And I think we've concluded that if it goes to the jury, based on the facts adduced through testimony, it's possible that there's liability and there's possible that there's not. Now, the district court granted a directed verdict, right? And the Court of Appeals affirmed. Was this in state court or federal court? It was in federal court. Okay, it's in federal court. So federal courts use the substantial evidence standard. Not always, but usually. Okay? Substantial evidence looks at both plaintiff's and defendant's case, right? When did Hardee's move for a directed verdict? At what point in the trial? Where in this picture? Here or here? This one? That's correct. Hardee's moved for directed verdict after the plaintiff was done with his case. Okay? At that point. Had the defendant put on its case yet? No. It had not. Okay? So even though federal courts typically use the substantial evidence standard, which looks at both plaintiff's and defendant's case, some state courts use the scintilla standard, which only looks to the evidence put forth by the non-moving party. Hardy's case is kind of like how things might go in state court, where we only look at the non-moving party's evidence. And the reason it's like this in Hardy's is because the defendant hadn't put forth any evidence anyway. All right? So here we're only looking at the non-moving party's evidence because there hasn't been any other evidence. Had we been in state court in a state that uses the scintilla standard, let's assume that Hardy's moved over here after all the evidence had been presented, right? In a scintilla jurisdiction, the court would only have looked at the non-moving party's evidence, right? So even though this isn't technically a scintilla case, it gives you kind of an idea of how scintilla works by only looking at the evidence put forth by the non-moving party. All right. Now, in this case, excuse me, I think I might have misspoken a moment ago. In this case, the district court granted a directed verdict, right? And the Court of Appeals reversed, saying there was an issue for trial, right? Where are we in the Hardy's case? Where are we? W, Q, or R in Hardy's? We're at Q. Plaintiff's evidence was kind of weak, right? But it was strong enough that we fell between X and Y, and we were within the realm where a jury could reasonably find for the non-moving party. All right? Now I want you to look at this chart for a minute. Can we resolve Chamberlain with Lane? Can we say that the two cases are consistent with one another? Actually, I have two questions. This is the first. Resolve Lane and Chamberlain. Jima?
Yeah, the cases are different because in the Chamberlain we have circumstantial evidence, while in this one we don't see the other party's evidence yet, so we don't know what's going to happen here.
I totally agree with the second part, disagree with the first. In both Lane and Chamberlain, we have a plaintiff's wanting the jury to infer facts from the facts given, right? So in Chamberlain, we're using Bainbridge as circumstantial evidence of an actual crash, right, involving the two chains of cars. In Lane, Mr. Lane and the managers, their testimony are being used by the plaintiff in the hopes that the jury will infer that no warning sign was posted and the water was put there by Hardy's, right? So in that sense, the direct evidence was being used for circumstantial purposes, okay? In that sense, the two cases are identical. Jahima is totally correct in pointing out a huge procedural distinction between the two cases. In Chamberlain, okay, when in Chamberlain was summary judgment sought? Here or here? That's right. Here's Chamberlain. Actually, I need a pen. There we go. Here's when Chamberlain was sought by the defendant, right, by the railroad. In Lane, the defendant sought directed verdict after the plaintiff's case, but before the defendant put forth any evidence. Okay? That's the difference. Now, here's a thought experiment. Go back to your thinking of Chamberlain. Let's assume that the railroad moved for summary judgment after the plaintiff finished the case, right? So, plaintiff puts on Bainbridge, and then plaintiff sits down and says, I rest my case, Your Honor. And now the railroad moves for summary judgment before the railroad has put forth all of its own witnesses. Okay? Where are we? W or Q? We're at Q. Why are we at Q? What's that?
Testimony is Bainbridge.
What's that?
They have one witness.
They had Bainbridge, right? Is it strong evidence? No. But based solely on Bainbridge's testimony, you can infer that that loud crash was those two sets of cars hitting one another, right? So what happened is if the defendant moved for a directed verdict in the Chamberlain case, after the plaintiff's case, we're at Q. Directed verdict should be denied. But directed verdict wasn't sought then. In Bainbridge, the defendant put on its own case, including a bunch of uncontradicted, direct testimony by people who had line of sight with the alleged place of the accident, the alleged site of the accident, pushing us from Q to W. Directed verdict? Granted. Now think about Hardee's. In Hardee's, the Court of Appeals said we're at point Q, directed verdict was inappropriate, it sends it back for trial. I suppose that if the defendant had put forth more evidence and moved for directed verdict after, we might have moved from Q to W, right? So why didn't the defendant wait? Why did the defendant, Hardee's, wait to do its directed verdict, to put forth its own evidence and take advantage of the substantial evidence standard in federal court, right? And then even if the plaintiff had us at point Q, now we can have both sides' evidence and go to point W, right, and get a directed verdict. Why do you think that is? That's my last question for the day. Why do you think Hardee's made the motion earlier, after P's case, rather than later, after both P and T put their case forth? Yes?
They may not have had any evidence.
Speak up.
They may not have had any evidence to go forward.
Can you hear? Good answer. Say it yourself. Back the room.
They may not have had any evidence to go forward.
Yeah, Hardee's may not have had anything else to say, right? Think about it. Who would Hardee's have called? It's the managers, right? So the defendants could call its managers as witnesses, I guess it could, but what would they have said that weren't already said during their testimony in the plaintiff's case in chief, right? So we speculate, but I think your speculation is good. I think the reason Hardee's moved for a direct verdict then, rather than waiting till later to take advantage of the substantial evidence test and doing this, is because maybe they just didn't have anything else. So they went for it, the directed verdict, after the plaintiff was done. Okay, thank you. Have a good day, have a good week. Remember, no class on Wednesday. See you Monday.